I might give people about 2 minutes and then I'll get started fairly promptly so we can make the most of our time together. Okay, let's get started and we'll let people join us. We have Costa, that's fantastic. Okay, it's my great pleasure to welcome you to our second panel for the day. This panel will be looking at conceptual and practical questions around realising the right to a healthy environment. We did originally have 4 panellists, but unfortunately, Dr. Erin O'Donnell is unwell today and unable to join us. Her paper was looking at some of those interesting questions raised by Dr. Pollina and sort of brought back up by Bronwyn. So that's an unfortunate omission, but hopefully we'll be able to see that in writing at some point. My 3 wonderful panellists today are Mr. Kevin Campbell from the ACT Human Rights Commission, Dr. Costa Agustinos, I'm hoping I'm not mangling your name, from the University of Technology in Sydney, and Associate Professor Bridget Lewis from the Queensland University of Technology. So I will hand over straight away to Kevin to get started with this presentation. Thank you, Kevin.
Hi everyone. First, I'd like to acknowledge that I'm joining from unceded Ngunnawal and Ngambri country and acknowledge the traditional owners of these lands and any other Aboriginal and Torres Strait Islander people joining us today. As a caveat, I'm not an environmental lawyer, I'm a human rights lawyer with my focus being on the ACT framework. My brief today has been to give a rather high level outline of some, but not all of the considerations that are being considered in the current consideration of the right to a healthy environment in the ACT. But I can talk to these in greater detail in the question and answer, if any questions. So for context, in February this year, the ACT Legislative Assembly passed a motion calling on the ACT government to investigate the inclusion of a right to a healthy environment in the ACT's Human Rights Act. This marks the first consideration in Australia, anywhere, of legislating a right to a safe, clean, healthy and sustainable environment. And I know there was discussion this morning about the Human Rights Council's resolution removing the word safe or not proceeding with that. These are the terms that the discussion paper has reflected, so we're proceeding on that basis. The public consultation about whether and how to recognise the right to a healthy environment closed at the end of August, and the ACT government is due to report back to the Assembly by the end of November, so we'll see more movement before the end of the year. It's been consistently affirmed, including by Dr. Fry, Chief Justice Preston and the UN Special Rapporteurs, that our lives, health, security, cultures, and indeed our futures depend on the quality of our ecosystems, biodiversity and sustainable development. Legislating a right to a healthy environment in the ACT would not only acknowledge this symbiosis and the importance of the environment as a core moral value of the ACT community, there are actually, in fact, numerous practical benefits that can be realised in bringing the right into the ACT's dialogue model of human rights protection, albeit these are not without some foreseeable challenges. If implemented effectively, what the right can do is foreground environmental harms, climate mitigation, adaptation, and cultural conceptions of what is a healthy country in activities across the ACT public sector. a range of our existing mechanisms would be applied to enrich environmental awareness of laws, policies, decision-making across all areas and functions of government, and not just located in, say, the Environmental and Sustainability Directorate. It would apply to all business across government. So among those mechanisms, one of the core benefits would be the application of the ACT's independent and early human rights scrutiny processes, which have been held up by authors DeBeljak and Grenfell as best practice within Australasia. The strengths of our scrutiny system include a dedicated human rights scrutiny unit within the executive, which signs off on all compatibility with bills before they're introduced. The ACT Human Rights Commission, for whom I work, we have a unique role in reviewing cabinet papers. We're the only commission that we're aware of in Australia that has insight into the cabinet process and the ability to comment as part of that. And then the ACT government as well has this as a laudable record of only introducing government bills assessed as compatible. So in terms of the legislative scrutiny culture, it's quite a strong safeguard for the right to a healthy environment. These interrelated processes, though regrettably invisible to the public, nudge agencies to address and justify human rights implications early in the development of draft legislation and cabinet documents. And this can have a similar benefit for the right to a healthy environment, including encouraging early and proactive consultation with members of the public, but also Aboriginal and Torres Strait Islander peoples. If the right to a healthy environment is enacted in the ACT Human Rights Act, the interpretive obligation under Section 30 would apply. Chief Justice Preston this morning was speaking about the ability of the right to a healthy environment to be taken into account in the interpretation of statutory discretions. The interpretive obligation under the Human Rights Act requires that, as far as consistent with its purpose, laws must be exercised in a way consistent with human rights. This would apply in relation to the right to a healthy environment, so as not to unreasonably diminish environmental protection or justice through the interpretation of ACT laws, including statutory discretions. Any laws that cannot be read compatibly with the right to a healthy environment could be found by the ACT Supreme Court to be incompatible. This does not necessarily invalidate them, but rather it prompts a response from the government in the Legislative Assembly, and so that downplays any concerns that one might have about the courts getting involved in setting environmental policy by stealth. At an operational level, agencies' statutory obligations to properly consider and act compatibly with human rights would extend to the decisions, activities, failures to act, but also proposals to act that impair the exercise of the right to a healthy environment. There's scope. We've talked this morning about the ACT having a direct right of action for individuals to contest contraventions of public authority duties in the Supreme Court. These, in theory, should motivate a culture of respect for human rights across the ACT government by ensuring that there's an avenue for accountability for, in the right to a healthy environment's case, ecological harm and broader issues that impair environmental advocacy or justice. Extending these mechanisms seamlessly to the human right to a healthy environment, though, have some practical challenges. Provisions and actions that limit the right to a healthy environment, for instance, by harming ecosystems or diminishing biodiversity, will not always be self-evident to the officials who are tasked with undertaking human rights scrutiny or policy officers who are preparing explanatory memoranda that justify limitations on human rights. Human rights scrutiny processes also don't extend to subordinate legislation, which is where you often find detailed planning and environmental standards. Standards of environmental regulation are also often agreed through intergovernmental arrangements, including with the federal government, and these commitments are then later translated into ACT laws and policy. So as Bruce Lindsay underscored this morning, realising a healthy environment will very much depend on the culture and awareness of human rights within the ACT public service, and particularly obviously the right to a healthy environment. Culture will be critical. For this reason, ministers, officials and operational staff will need to be equipped both by new working relationships, by accessible guidance, ongoing training and effective consultation with traditional owners so that they can know, understand and when and how the right to a healthy environment and cultural rights will bear on their functions and decision making. So moving away then from the culture of the public service, there's another conceptual challenge that related to recognising the right to a healthy environment in the ACT, and that's an assumption in the ACT government's recent discussion paper that the human right to a healthy environment should be understood wholly as an economic, social and cultural right, an ESC right. Now, I acknowledge that distinctions between ESC rights and civil and political rights are nowadays very considered to be artificial, particularly because all human rights are indivisible, interrelated and interdependent. The right to a healthy environment in particular underscores this false dichotomy in that its substantive and procedural elements derive both from civil and political rights and economic, social and cultural rights, sometimes simultaneously. For that reason, it's very much important that the jurisprudence commentary and other resources relevant to civil and political rights, like the right to life, privacy, equality, expression in terms of the procedural rights, it's important that these equally inform the rights application in the ACT and that they're not precluded by sort of an arbitrary confinement of the right scope. The right to work and rights in work are currently in the ACT the only rights that are structured as being capable of progressive realisation, meaning to the maximum extent of available resources. And so because the right to work was only introduced in 2020 in the midst of the pandemic, it hasn't yet been considered by the ACT Supreme Court. This means that the interpretation of ESC rights in the ACT remains untested and uncertain. And as Melanie referred to earlier in her presentation, for many litigants, there's already lesser incentive to test out novel environmental arguments, including rights-based arguments, given the limited jurisprudence that currently exists. It's kind of like going out on a limb. So without this judicial guidance, scrutiny processes too much struggle to develop their methodological approach to interpreting ESC rights. This is particularly so because the ACT's existing scrutiny processes, both pre-enactment and parliamentary scrutiny after introduction, consider specific laws in relative isolation. They don't look to the broader legislative frameworks that inform them or overall budgetary picture. Environmental duties under the right to life and privacy have also recognised some leeway for governments to balance appropriate levels of environmental protection with other social goals. So to the extent that framing as an economic, social and cultural right is potentially seeking to minimise resourcing fears, this is unnecessary. That's not to say that there's not benefits in economic, social and cultural rights and recognising the substantive obligations under the right to a healthy environment that come from them. For instance, rights to health, food, water. And in fact, this is consistent, sort of lays the groundwork for the ACT to later expressly recognise the rights to health, the right to water, the right to food in the Human Rights Act in their own right, which is quite significant. As a final observation, and trying not to go over time, the ACT needs to not assume that its legal framework will already satisfy the rights to a healthy environment. And this is particularly so in relation to the procedural entitlement to access effective remedies. Although we've discussed that the ACT does have a direct right of action for people to contest breaches of human rights in the Supreme Court, this pathway has been historically underutilised in the ACT and overlooked by our legal profession and broader community. Because human rights litigation involves significant cost, stress and delay, the direct right of action alone might be actually insufficient to guarantee effective remedies, especially for those experiencing vulnerability. These concerns have been recently examined in an inquiry by our Standing Committee on Justice and Community Safety, which recommended that the ACT establish an administrative human rights complaints mechanism. If agreed by government, and we'll find out within the next 2 weeks whether it is, the ACT Human Rights Commission and the ACT Civil and Administrative Tribunal would be given the ability to take complaints about breaches of human rights duties by government agencies, and that might involve conciliation and potential resolution through the tribunal. Establishing a human rights complaints mechanism would empower individuals to themselves take action where they believe their right to a healthy environment has been infringed. In this way, administrative complaints can provide a meaningful, affordable, and timely means to achieve environmental justice for those vulnerable to environmental risk and climatic harm, for whom litigation may be inaccessible. So more importantly though, and going back to that point that I made earlier, with the culture of public service being critical, a complaints mechanism provides a way to make sure that the right to a healthy environment, once enacted, if enacted, becomes real and relevant to the daily work of public service agencies. It is this that will be a critical ingredient. And so, as I said, I'm very much looking forward to the government's response toward the end of the month it is this that's necessary to promote a kind of human rights culture necessary to fulfil the right to a healthy environment in the ACT. So that concludes my remarks.
Thank you so much, Kevin. That was brilliant. And it provided us with a really lovely overview of some of the really exciting things that are happening in the ACT and some of the detail that we need to make sure that we're quite alert to and perhaps critical of as it comes out. I'd like to now hand over to Dr. Castor Agustinas, who will be presenting his argument for an implied constitutional right to a healthy environment, which picks up on one of Melanie's points earlier. So it's really fascinating to hear. Thank you.
Thank you. Would you mind putting up my slides? Oh, there we go. Wonderful. Thank you. All right. So today I'm putting forward an argument that a right to a healthy environment may be implied in our Constitution. To make this argument, let's first talk about constitutional implications. So next slide, please. All right, so the Constitution, this is a bit like Constitutional Law 101. So hopefully this is useful for you all. All right, so the Constitution is written in a skeletal way. The High Court accepts that finding things implied in the document is vital to flesh out the details. When the court has found implied rights in the Constitution, it's about protecting the Constitution itself, because certain rights are needed for our constitutional system to function. Okay, so it's not about what we typically think of when we think of rights, which is the intrinsic value of human life or the promoting human flourishing. It's just about protecting the Constitution itself. So let's look at an example on the next slide, please. The implied freedom of political communication. Okay, so you won't find the words free speech anywhere explicitly in our Constitution. The High Court established that it's implied in the document using the following formula. So basically, our constitutional system needs people to be able to speak freely on politics so that parliament, elections, etc. can run effectively. Thus, our Constitution implicitly forbids the Commonwealth and states from compromising people's free political speech. Okay? We heard an example before by Justice Preston, the 2017 Bob Brown case, where basically the court forbid a Tasmanian law restricting environmental protests in certain forest areas because it breached this implied freedom of speech. Okay. So the implied right to a healthy environment that I am proposing would follow a similar formula. So next slide, please. Okay, so just like free political speech, our constitutional system needs a healthy environment. The Constitution, therefore, I would argue, implicitly forbids the Commonwealth and states from destroying this environment. So let's focus on that first point. Why does our constitutional system need a healthy environment? So this is the basis of proposing this thing is implied in our Constitution. So let's go to the next slide. I'm going to discuss this in the context of climate change. Okay. So to paraphrase Justice McHugh, our constitutional system is meant to be kept in good condition to be passed on to future generations for centuries to come. So in constitutional law, we think long term. Climate change threatens our constitutional system in a number of ways in the long term. So for example, how can we ensure our politicians, judges, and institutions are not vulnerable to corruption if food and water insecurity are rampant? How can elections and government functions run smoothly if fires, floods, disease, and more escalate? What tensions between the states will emerge due to shared water sources drying up? So these are just a few examples of ways in which climate change might pose a threat to our Constitution. So next slide, please. All right, so up here is a diagram of what we do not have, So we need to understand climate change as a threat to our Constitution. Our constitutional system and our ecosystem are not separate things operating in separate spheres. Next slide, please. This is a better way to understand our system. Our constitutional system exists within and is dependent upon this ecosystem. If this ecosystem falls apart, so too does this constitutional system built within it. Next slide, please. So this is the dynamic that we have at play. The Constitution empowers government, and by fueling climate change, the government is damaging the Constitution. This is why such government action may be argued to be implicitly forbidden. The High Court views the Constitution as not granting governments the power to hurt itself. So to tease this out, let's look at an example. So next slide, please. All right, so let's look at an example of government approval of the Adani coal mine. So I'm basically proposing that this might be in breach of the implied right to a healthy environment if it was established. So the Adani coal mine, if built, this mine would release a lot of carbon, fueling climate change and thus hurting our constitutional system. For this reason, government approval of this mine may be in breach of the implied right to a healthy environment that I'm proposing. Of course, some challenges may be made to this argument. I just want to say at this point, so obviously I'm dramatically oversimplifying everything to stay within 10 minutes. But let me go to the next slide, please, and we'll go to some sort of pushback that an argument like this could get. Okay. So one might argue, first off, that this mine does not single-handedly bring about climate change and destroy our constitutional system. Okay. This, however, is not how implied rights work in constitutional law. No breach of an implied right single-handedly destroys our constitution. So, for example, the Bob Brown case that Justice Preston brought up before, so that this Tasmanian law restricting environmental protesters, that does not come close to single-handedly destroying our democracy or our constitutional system. Yeah, if that law goes ahead, it's not going to be the end of everything. Okay. But the reason why the court said, no, that's in breach of this implied thing in our constitution is because the court is sensitive to how such action might incrementally or partially chip away at our system. Yeah, it's actually very harmonious with how we talk about climate change. Climate change is a death by 1,000 cuts kind of problem. And similarly with constitution, keeping the structural integrity of our constitution, that's a death by 1,000 cuts issue as well. Okay, so, yes, these kind of things do not single-handedly destroy our system, but they are a substantial cut that is unacceptable and might harm it. So let's go to the next slide. All right, so another argument that could be made is what about, is taking into account the benefits of the Adani coal mine. Specifically, the economic benefits of this mine, shouldn't that be considered? And basically, I would agree with this. All right, the High Court formulates implied rights with a proportionality test for this reason. This test basically requires the court to permit the government to do what it wishes if it's for some benefit that's worth the potential damage to the Constitution. So a proportionality test, it's basically a balancing act. Yeah. Is this government action needed for some greater good? With the Adani coal mine, so let's say the implied right to a healthy environment is established and it's formulated with a proportionality test, you would have to balance the ecological damage of this mine versus its economic benefits. And I think the argument can be made that the economic benefits of this mine are not particularly strong, so it's not worth the damage to our constitutional system. Let's go to the next slide, please. All right, so another final counter-argument that I'll bring up is judges, is this argument that is that the implied right to a healthy environment would require judges to be too political, okay? For example, judges may have to make environmental value judgments regarding the mine when doing the proportionality test, okay? And judges getting involved in economics makes people very uncomfortable. There's a few problems with this. One problem with this is that such value judgments are not just economics, but national security and other big politically charged issues are the norm in constitutional law, okay? And there's a further argument I want to make on the next point, on the next slide, please. All right, So a further point I'll make is that judges are the guardians of our constitution and the watchdog of the government. And if we accept this point that government action fueling climate change threatens our constitution, it would be a dereliction of the court's duty not to intervene. So while these are some of the challenges that the implied right to a healthy environment might face, I want to end with some of the implied right's unique strengths and why it's worth pursuing. And I'll just be mindful of the time because I know my time's running out. So next slide, please. All right, so one strength is that the argument I put forward for an implied right to a healthy environment could be taken to court now. It's based on the existing text and structure of the document and existing precedent on how implied rights work. So I'm actually making a very black letter law argument based on how everything already exists. Okay, so you don't need a referendum to put this in place. Next slide, please. Another strength is that the Constitution is the one law above government that they must obey. This is different from environmental protection legislation, which too often we have seen government simply rewrite and weaken whenever it gets in their way. This is the one law they can't rewrite. Just to finish off, so big societal crises like World War II and the Cold War have often been the catalyst for discovering new things implied in our Constitution. Our constitutional system has always relied on a healthy ecosystem. It's only now, however, with climate change and other environmental threats looming, that we need to pay attention to this relationship and join the dots on what might be implied in the Constitution to protect its ecological foundations. This crisis is not going away. The argument for the implied right to a healthy environment will only get more obvious over time, but the sooner we recognize this, the better able we will be of passing on a healthy constitutional system to future generations. All right, thank you very much.
Thank you so much, Costa. And it was a little bit of an excellent lesson too in very clear speaking in terms of how we can kind of get these complex ideas across. So thank you very much. I'd now like to hand over to our third and final speaker for this panel, Associate Professor Bridget Lewis, who's looking at the issue of standing. Thank you.
Thank you. Let me just do a little bit of clicking. Okay, you can see those slides okay?
Your screen seems to be loading for us, I think.
Oh, that's okay.
They're a little bit small, but we can see them.
Hang on a second. Sorry, I'm glitching up here.
I think Bridget's probably re-logging in order to
Sorry,
yep.
I don't know what happened there, but my Zoom kept crashing. I wonder, Lydia, maybe if have you got my slides there to set them up?
Yeah, I do.
Thank you. It's technology is fun, right? Okay, wonderful. Thank you so much. If we can skip just to the next one quickly, Lydia, thank you. I'd like to begin by acknowledging the Turrbal and Yagara people as the First Nations owners of the land where I work and live, and I pay my respects to their elders and extend that respect to any First Nations people who are joining us today. If you can pop to the next one. So as Christy said, I am going to talk about standing to enforce the right to a healthy environment, which I realize could be kind of dry and boring, but hopefully I can kind of persuade you that these sorts of questions are actually quite important and interesting when we're thinking about what the right to a healthy environment protects and what we want to be able to do with it. The resolution that was adopted by the General Assembly in July recognises that all people have the human right to a clean, healthy and sustainable environment. It calls on countries to scale up efforts to ensure the enjoyment of that right, but it doesn't say very much about exactly what government should be doing, and it's silent about enforcement. Now, I mean, General Assembly resolutions aren't legally binding, and it's quite likely that the international community wasn't intending or isn't intending for the right to a healthy environment to be legally enforceable. But if we're contemplating recognising it in Australia, then I think it's worth considering how this right could be enforced. And I think so. I think that's important because enforcement is really closely linked to how we define the right and what we can achieve with it. And obviously, if we're talking about enforcement, then a key issue is standing. Who might be able to bring an action and under what conditions? So I want to look at some of the case law from different jurisdictions and see what sorts of challenges exist, how they've been overcome, and then consider what we might learn from those experiences for Australia. Can we go to the next slide? Before I look at some of the cases briefly, and this will be very, very brief, I won't get too bogged down in case law, but I just want to raise a couple of points about the definition of the right. So when we're talking about environmental rights generally, we look around the world, we've got a wide range of variations of the right to a healthy environment. And we can put these on a spectrum from anthropocentric to ecocentric. At the anthropocentric end, a healthy environment is defined as one that's good for human health. So it's instrumental to human well-being in some way. At the other end, we've got more ecocentric definitions that aim to guarantee an environment that's healthy in its own right. So it's not linked to human welfare. And, you know, then we've got a whole bunch of things that fall somewhere in between. And that exact meaning or the scope and content of the right is usually left open to interpretation. But the way that it's defined will have an impact on enforceability and particularly on standing, because it influences how we assess when a person has been injured and whether there's been a violation. So I'm going to be talking in general terms about the right kind of as it's framed in the General Assembly resolution, a right to a clean, healthy and sustainable environment. But that's a fairly broad, perhaps vague concept itself. So I think it's worth bearing in mind that the specific issues of standing are going to vary with the nuances of the way that the right is defined. And of course, some of the human rights regimes that I'll be talking about don't recognise the right to a healthy environment as a separate right. They usually just recognise the environmental dimensions of other rights, like the right to health or the right to private and family life. So that complicates things further as we're looking across different regimes. On to the next slide. If we have a look at the jurisprudence, generally speaking, in relation to standing, complaints to a human rights body will be admissible when they come from an individual or a group of individuals who are victims of a human rights violation. So we're talking there about that victim status as the kind of threshold for making a complaint. The UN Human Rights Committee looked at this issue of standing in EW in the Netherlands and said that to be a victim, a person has to show either that their rights have already been adversely affected or that such an effect is imminent. You can't bring a complaint on an actio popularis or a public interest basis. That was confirmed in Anderson and Denmark, where the committee explained that a person can't claim victimhood in theoretical terms or on behalf of a collective interest. They need to show that there were specific consequences which personally affect them. Next slide. Thanks. In 2019, the Committee on Economic, Social and Cultural Rights looked at standing in relation to the Covenant on Economic, Social and Cultural Rights and in SC and GP in Italy, and said that, again, claimants have to be either real or potential victims. They have to show that personal impact on their rights, not just a general concern about the state's actions. The European Court of Human Rights uses a similar test. There, for a claim to be admissible, the applicant has to face a serious, specific and imminent danger. Next slide, thank you. So I think what we can do there is really kind of distill all of that down into two key requirements. And the first is that we're looking for a certain degree of specificity of harm that's facing the applicant. They have to be particularly affected either as individuals or as members of a particular group. And the second requirement is that the harm has to have either actually occurred already or it has to be imminent. Usually fairly straightforward to show that there's been actual harm, but we've seen issues pop up where a person is claiming victimhood based on imminent harm. And some of the cases have kind of unpacked what imminent harm looks like for the purposes of standing. It was considered by the Human Rights Committee in Tatiota and New Zealand, which was a case that involved the risk of harm from climate change that was facing the applicant if he was deported back to Kiribati. And the Human Rights Committee said that for the purposes of admissibility and standing, imminent harm must be something more than a theoretical possibility. The European Court uses the language of being not speculative. So, I mean, in a lot of these are kind of climate change cases, and I think in a lot of cases now, we can be confident that the harms from climate change are more than a theoretical possibility, but that's difficult when you're linking that also to the need for a specific harm to an individual, because while something might be foreseeable, it can be hard to show that necessary personal impact. So I think that we've got challenges for both of those requirements when we're looking at the right to a healthy environment. It'd be fairly easy to establish standing if you're living near a polluted waterway or next to a toxic waste dump or something like that. And we've seen that those sorts of cases be successful in other places. But if the environmental harm that you're concerned about is more generalised or it's more remote, if we're looking at, say, the loss of habitat or an inappropriate development that's threatening an ecosystem, then it might be more difficult to show that necessary personal impact. Can we go to the next slide, please? So to look at a recent case that helps to tease some of this out a little bit more in relation specifically to climate change. We've talked already a couple of times today about the Torres Strait Islanders case before the Human Rights Committee, the decision that came down very recently. And in relation to questions of standing, the committee recognised that the loss of, or the environmental impacts, the loss of marine ecosystems, the impact on land and waters for the Torres Strait Islander applicants in that case were enough to establish the personal impact because of their cultural importance. So the ecosystem, the environment more broadly, had that cultural importance, and that then translated into the personal impact for those applicants. But if the context is different, without that cultural connection, it might be difficult to get those sorts of harms before the committee. And I worry that by perhaps putting too much reliance on cultural arguments, that we place a burden on First Nations peoples to action these sorts of claims via their link to culture. I'm going to skip over the next slide. There's just a few kind of comments about public interest pathways that exist in other places. And there are some jurisdictions that allow environmental rights to be actioned through a public interest pathway. But that's, a long way from what we have in Australia. So just to wrap up by asking whether this stuff matters, I think we've got some challenges if we're trying to use conventional approaches to standing to enforce the right to a healthy environment. It may be that doesn't matter too much. The General Assembly resolution has value even if it's not legally binding. I think the right to a healthy environment has value even in an unenforceable sense. But I think if we couldn't enforce it adequately, then we might come to question its contribution or perhaps even its legitimacy. And so I think that kind of also then points to a question about how we define the right. We've seen the easy cases are the ones where other human rights are already impacted. So I think that raises a question about whether the right to a healthy environment is capable of doing something kind of on its own, distinct from other human rights, or if it's really just a restatement of the environmental dimensions of human rights that are already protected. So I'll leave those questions. Maybe we can pick some of them up in the discussion. Thank you so much.
Thank you so much. So now we have 20 minutes for discussion. So if you do have a question, please either use the reactions to put up your hand or pop it into the chat. I'm going to kick off just because there's one that I'm really interested in. I'll start with you, Bridget, but I would be interested in the views of the other panelists. In relation to this issue around standing, obviously there are these limitations in terms of this requirement of sort of individual or collective harm and the imminence question and things like that. But to go back to a point that you made towards the start of your presentation, one of the main issues I can see is that it really reinforces the anthropocentrism of the right, in that if you're not able to do a kind of a public interest claim, which is sort of representing the environment by proxy, and we've yet to have any recognition of kind of legal personhood within the context of human rights regimes, how do we actually get at that kind of recognition of the intrinsic rights of the environment within this context?
I really wonder if we can, Christy. I think that it's one of the problems we will always run into if we're trying to work within the human rights system that we have currently, and which isn't to say that it's not worth doing. I think there are still benefits from it, but I think that there's always a risk that we put our efforts in that space and we don't work on the other stuff. And so I really think in some respects, I don't know, I have questions about exactly what the right to a healthy environment does as its own concept if it's within the traditional human rights framework. And standing is one part of it, but I think that it's inextricably anthropocentric then. Once you put it there, that's how it will always kind of fit. And so I think that perhaps the one pathway out of that is really to look at these sorts of questions about what sorts of actions can we bring to enforce it. And I think we have to be creative there. I think we would really need to look at those sorts of public interest pathways so that we really could tackle something that's bigger than just little impacts on small groups. And so, yeah, it's a very good question.
Costa or Kevin, did you have anything you wanted to add to that? And then I think Beth has a question.
No, I would only say that I fully agree with Bridget. It's the limitation of a human rights system is that it is inherently anthropocentric, and the point that you made in your presentation about cultural rights, to the extent that import an understanding of country that is holistic, that includes people, that includes the environment, that includes ancestors and kin. To the extent that those would be overly relied on, that's an unfair burden to place on Aboriginal and Torres Strait Islander people. So that's, within a human rights system, that's the only way that I could see of making those arguments.
I have nothing really to add, so I'll leave it with that.
Beth.
Thanks. So actually, Costa, I did want to ask you about sort of constitutional questions, just in terms of the process of recognition of Indigenous voice to Parliament, and the process that we're about to go through with the referendum, and how we see that in terms of this right, and potentially altering our constitutional framework in terms of Indigenous input into decisions and that are made about all our laws and policies in this country, and whether that might in some way also take us towards the realization of this right. But yeah, the question is for anyone.
Well, what a question. So first off, I would say, I'm not really an expert on the voice and what's being proposed there, but obviously I know, a good amount about it. I would say, yes. I mean, I think sort of, I don't have a clear answer for you. I don't think a clear answer is there. It sort of goes into the category of the idea of the voice, if it's implemented as part of the Constitution, it will look at laws and policies of the Commonwealth that affect Aboriginal and Torres Strait Islander people. And so sort of the $1 million question there is what fits into that box? Yeah, like what affects them that the voice now has the ability to, get in on the ground floor and, discuss with government. Yeah. Correct me if I'm wrong, everyone, but I still think it's pretty unclear what exactly would fit into that box. So things in terms of environmental law, etc., how much they sufficiently link to Aboriginal and Torres Strait Islander people would kind of have to be the thing that would have to be answered there. I think a really good argument can be made that it will, but I think a lot of people that oppose the voice, and people that are just like a bit nervous about the voice, they would sort of push back on this, because the idea is like, well, if this voice comes in, like what doesn't affect Aboriginal and Torres Strait Islander people? Yeah, like does this thing called the voice, does it get to talk about, welfare laws and criminal laws and laws about this and laws about the environment? Yeah. So I wouldn't be surprised that if the voice gets over the line, there might have to be some kind of like limiting of these are the kinds of topics that affect Aboriginal and Torres Strait Islander people that the voice is allowed to have this, advisory role with. So I don't think there is an answer out there yet, but I think those are the kind of dynamics that would affect whether the right to a healthy environment would fit in there.
Kevin or Bridget, is there anything that you wanted to add in relation to that question?
No, that would be straying outside my ACT bounds.
And do we have any other questions for this panel? Kevin, I wanted to ask then, I'm just going to jump in while there's a void available to me. In relation to the ACT, I wondered if you could explain a little bit more about what kind of mechanisms would need to come in to support the Human Rights Commission if this right to a remedy if those mechanisms do get approved, it's going to significantly change the way that you guys operate at the moment. And has there been any discussion around how that, might work, and particularly if it then encompasses the right to a healthy environment, would there be a need for some sort of kind of departmental cooperation in relation to, the Commissioner for the Environment and things like that? Has any of this been given?
So certainly there are matters that we've highlighted in our submission to the public consultation, and I believe they've been echoed in other submissions too. The submission is also available on our website, the ACT Human Rights Commission's website, if anyone's interested. But as I noted, human rights scrutineers don't necessarily have the ability to know when a proposed law is going to have downstream implications for biodiversity or for or just environmental harms or climate mitigation in general. Historically, in scrutiny roles that I've been in, when we've received legislation setting climate targets, they've just been sort of numbers that we are not able to understand the background of. So it also relies on strong, cogent, and quite accessible justification and explanatory memoranda. I imagine that will require some support for our agencies across the ACT Public Service. One of the other discussions, and this is just a discussion that we've had internally within the Commission, has been whether or not there's scope for greater training for the public service about cultural rights and the right to a healthy environment in that context. just again to contribute to making that culture real. The ACT Auditor General in 2019 identified that there were opportunities in the ACT government to increase awareness and understanding of human rights, particularly through publication of guidance sheets. Those guidance sheets were published, I think, last year. However, it was with a whimper rather than a bang. So, yeah, very much in terms of communications, there are those opportunities in the ACT.
Thank you so much. Julia.
Thanks so much, everyone, for a really fascinating panel. I guess picking up on sort of Kevin's comments about developing a culture around rights in the public service, I sort of wanted to ask a question about what the obligations are on us as legal teachers and educators also to create a culture around knowledge of this right to a healthy environment and how we might do so, particularly through our teaching. It seems to me, particularly listening to Costa's presentation, it is such an exciting right, but idea, but it feels like it might be a while off before we have recognition from the judiciary of such an implied right, and maybe by socialising this idea with students across the country might be the way to sort of bring it into public consciousness much more and sort of gain that acceptability that, you know, might be picked up by the judiciary over time. So I just sort of want to, I guess, a broad question for all of the panelists about what is our role as legal educators also in sort of creating a culture that's more open to that right to a healthy environment in the work that we do, both in teaching environment law subjects, human rights law subjects, but also all the other legal subjects across the curriculum.
Oh, well, I'll jump in if no one, if no one else is keen. Well, can I say, like, the implied freedom, I'm so in constitutional law, I apologize everyone, but you know, the implied freedom of speech that we talked a little bit about, that the court established in the 90s, part of the story there, which I think is really interesting, is there's always been talk, which is the judges in the Mason Court sort of got their education or were very much schooled in thoughts in the 60s in law school, all about the Constitution's more flexible than you think, you know what I mean? And the importance of these rights. And so a lot of people sort of draw a line there, which is like that sort of soften the ground, that kind of education for when they got into positions of power. This thing that might have seemed ludicrous to judges a generation earlier seemed, you know, normal to them, you know, at that stage, and they're now, you know, in the driver's seat. So just generally, absolutely, I think in terms of just sort of softening the ground to these ideas and, you know, getting people just thinking about these ideas in law school, I think is really invaluable. Someone in the chat mentioned Nicole Graham, and she's done a lot in there. So Nicole Graham used to actually work at UTS, and I actually used to work with her, and in the foundation subject, like introduction to law, she just put in some earth jurisprudence, which was like the first time I had ever heard of it. And I now had to be an expert on it and teach it. And then it just became like a normal part of the syllabus, and it just sits alongside, you know, feminist jurisprudence and other things. And it's interesting because it seemed like such a weird alien idea, but now it's just like a cornerstone of our, you know, of our syllabus. And students, you know, like even if they don't like it, like they at least have to just like marinate in the ideas of it, and then next week they'll learn something else. But you know, it sort of just like helps in that way.
We're just going through a process at QUT of looking at the curriculum and trying to more consciously embed some of these ideas. The university's calling it a project to embed sustainability, and every time we meet to talk about it, we get our heads all caught up about exactly what we mean by sustainability and whether that's the concept we want and so on. But we, you know, we have also, you know, been looking at Nicole's idea that all law is environmental law, you know, and that these are concepts that have a place. And actually a part of that is our responsibility to be producing graduates who are ready, and their work is increasingly intersecting with these sorts of issues as they become more present. So it's partly, you know, wanting to indoctrinate the next generation of lawyers to think the way we do, but it's also probably part of our responsibility to get them ready for practice.
I would just add as well, there's a role for legal educators to play in building the confidence in the legal profession to test out some of these human rights-based claims or other strategic environmental litigation. At least in the ACT, the Human Rights Act hasn't really been well taken up in terms of litigation. There's, I think, in terms of the public authority obligations, there's an estimated less than 50 matters that have run these sort of claims. So particularly what I noticed in Queensland, by contrast, was when their Human Rights Act began, there was a sort of stream of articles suggesting how that Human Rights Act could be used for climate litigation, which has, I'm not going to draw a link and say that it culminated in the Waratah coal case, but certainly as a lawyer, you would look to what sort of theoretical possibilities are out there for arguments to build that confidence to run them.
Fantastic. Unless anyone wanted to jump in with a quick 1-minute comment.
There's a
Gillian?
comment from Gillian in the chat.
Oh, my apologies. Yes. So Gillian is asking whether the right to a healthy environment is the best language for describing a latent constitutional protection. So I'll let you.
Thank you, Gillian. That's a really good question. You know, it's funny because the thing we're talking about is something implied in the Constitution, so there is no explicit wording for it. Everything I talked about today actually comes from a PhD I recently did, and in that I actually, very much along the lines of what you're saying, I actually called this thing an ecological limitation, because often the language in constitutional law is like a limitation on government power. Yeah, so the Melbourne Corporation limitation, the Boilermakers limitation. Yeah, so I said this is a limit on government power to protect the ecological foundations. And also, I thought if I call it the implied right to a healthy environment, you know, I just wanted to pass my PhD. So I thought that just gives me more confusion than I need. You know what I mean? Like, because it might get confused with the right to a healthy environment in other constitutions, which are more about protecting the rights of humans, etc. And our rights in Australia are just very much bloodless, kind of. We want to protect the Constitution itself, and if we help some humans along the way, well, okay.
Thank you so much. Well, that concludes our second panel. If you could all join me in thanking our 3 wonderful speakers. If you want to grab a cup of tea or a biscuit or something of that nature, we'll be starting our 3rd panel looking at the intersections with climate change at 2:10. So thank you so much.